Principal Public Interest Monitor. He's a long-serving former director and president of Berry Street, Victoria's largest independent child and family welfare agency, and the immediate past chair of the Phoenix Australia Centre for Post-Traumatic Mental Health at the University of Melbourne. Michael has served on boards and committees of numerous other organisations. I believe this will be a fascinating presentation. Over to you, Mike.
And thank you for having me here to your Probus meeting. First of all, I apologise for being so informally dressed. I hadn't appreciated that you gentlemen would be dressed the way you are. You'd be amazed how informal and casual business dress is in the city is today, not perhaps like your days or mine, but that's the way it goes these days. Good to see Jim Duggan here, my dear friend, who approached me and asked me to speak today. When I've given talks in the past about my work, it has usually been on themes of crime and punishment, corruption and so on, reflecting the work that I've done. And today I'm going to say a little bit about my current role because I'm permitted to say very little. I'll explain that in a moment. And then I'm going to tell some stories after my 53 years or so in the law. I think it's time for me to tell some of those amazing stories. Now, often when barristers say they are going to tell stories, people head for the door. We call these stories worries or war stories, and most of these stories are about the great forensic triumph of the person telling the story. But my stories today will not be on that theme at all, I promise you. Now, my current role. As you've been told, I'm Victoria's Principal Public Interest Monitor. A long title, but in fact quite a narrow and small role. The work of our office, and we're a very small office, involves monitoring a small part of the activity of Victorian law enforcement agencies, mainly Victoria Police. And we monitor in the area of telephone intercept applications, surveillance device applications, if law enforcement want to put a camera into your house to monitor your suspected criminal activity. We monitor the use by Victoria Police of certain special powers in the counter-terrorism area, and we have some other witness protection, we have some other functions as well. Under the statutes under which I operate forbid me from really talking about my work. In fact, our annual report is 8 pages long, because the report to Parliament, because it's prohibited for us to reveal very much about what we do, because it's in the area of covert police activity and involves methodologies that Victoria Police don't want everyone knowing about. But I can say a little about what we do because it's in the annual report. And just to give you an example with regard to applications for telephone intercepts and surveillance device warrants, when those applications are made to courts or tribunals, the people who are going to be affected and whose privacy is going to be affected obviously don't know what's about to happen. They can't be told, obviously. That would defeat the point of getting the warrant. So our role is to look at the applications that are being made and see if something needs to be said on the other side. Of course, the applications are made by the law enforcement authorities. There are affidavits and other paperwork, and of necessity they're likely to be a bit one-sided with the best will in the world, because the application is being made and the affidavit is being sworn by the law enforcement agency. So we look at them to ensure that what's proposed is fair and appropriate in the circumstances. And we might have a concern, for example, that there isn't sufficient evidence that the person who's being investigated has been involved in the relevant criminal activity. We might be concerned that the person whose telephone is about to be intercepted isn't actually using that phone, it might be his wife's phone. We might be concerned that a camera is going to be put into somebody's house when we think a microphone would suffice, those sorts of things. So we look at the applications that are made, and if we think something needs to be said to the court or the tribunal in opposition to the application, we go along and say what needs to be said, and we can ask the police to provide more information, we can question them about what's proposed and so on. So, public interest monitor. And that's about all I can say about what we do. There are only 5 of us. You won't find us in the phone book. You won't find our name on the directory in the building we operate. We pretty much operate in secret. So that's as much as I can tell you. Now, I'm going to tell 2 stories. And you tell me, Simon, if I'm talking too much, I'll shut up. I'm going to tell a story about my dramatic day ever in my 53 years in the law. And then I'm going to talk about my most embarrassing day as a judge. And Jim knows that particular story, but I don't think he knows the first one. My dramatic day ever in the law was on the 21st day of May of 1980. I was appearing in a case in the Supreme Court. It was a fraud case. It was a Ponzi scheme. I'm sure you all know what a Ponzi scheme is. Recent example, allegedly, Melissa Kadich. People running investment schemes, spending investors' money on paying dividends to other people and so on. Sometimes the promoters of these schemes start off with good intentions, but they can't live up to the promises they've made to investors, and then they start pinching investors' money to pay dividends to other investors, and of course gets into a death spiral. So this was a pretty big case. I can't remember the amount of money involved. There were 4 men on trial for this fraud before Mr. Justice Barry Beach in the Supreme Court. There were about 8 barristers involved in the case, all arrayed along the bar table. And so it was just an ordinary day in May, and we were sitting in court listening to some evidence. I think an accountant was giving evidence. Accountants are very nice people, but their evidence is sometimes not very interesting. We were all probably feeling a bit sleepy as we listened to this evidence on that May morning. Meanwhile, down the corridor in courtroom number 9, Jim will remember courtroom number 9 upstairs of the Supreme Court, a civil case was winding up. And the judge was Mr. Justice Clive Tadgell, who sadly passed away last week. And it was a case, it was a bitter family dispute about money. And believe me, all family disputes about money that end up in court are bitter. And this was a bitter case. And Mr. Justice Tadgell was going to be delivering judgment that morning. And one of the men involved in the case, a man named Kraja, K-R-A-J-A, I won't mention which country he came from, but it was in the Balkans somewhere. He wasn't optimistic about the result of the case because he brought a gun with him to court, a handgun. And when, as anticipated, Mr. Justice Tadgell gave evidence, found against him, gave judgment against him, Mr. Kraja followed the other side, the witnesses on the other side and the interpreter and so on, followed them along the corridor and shot 2 of them dead and critically injured a couple more. And all of that happened right outside courtroom number 12, where I was appearing with the 7 or 8 other barristers in this case before Mr. Justice Beach. Now the Supreme Court is a beautiful old sandstone building, but you can imagine the sound of about 8 gunshots going off in the corridors of a building like that. It was terrifying and very loud. And I was 30 feet away. And one of the people who had been shot and badly wounded tried to escape into the airlock, the double door system, into our court and collapsed on the floor. Very dramatic, very tragic circumstance. Now, Mr. Justice Beach decided that obviously the jury, this was in the morning, mid-morning, the jury would need to be sent away for the rest of the day to give them and everybody else an opportunity to recover. Mr. John Winicky, a legendary barrister and former judge, wonderful man but a pretty tough operator, he thought sending them away for the day was a bit excessive. Couldn't they have a cup of tea and then we could get on with it after that? hard man, good man, but hard man. Anyway, Mr. Justice Beach sent the jury away for the day. Now, earlier, I'm sorry, there were, as I said, 4 accused men involved in that case, but one of them wasn't in court that morning. Unusually, he had been given permission to attend a medical appointment, and because the evidence that was being given that morning didn't affect him, it was agreed that the case could go on in his absence and he'd go to his medical appointment and come back, and the jury were told that. Anyway, Mr. Justice Beach sent the jury away for the day after shooting, and the jury were walking down Little Bourke Street as a group, heading down towards Elizabeth Street, and the accused man who'd gone to the doctor, whose name was Richard Ursley, he was a sort of pleasant young man, but he was the salesman in the Ponzi scheme, convincing young fella, I'm sure. So he's coming back from the doctor up Little Bourke Street, and the jury, 12 of them, are walking down Little Bourke Street. And a conversation breaks out between Mr. Ousley and the jury. Now, one thing defence barristers always tell their clients is you must never, ever, under any circumstances, speak to the jury. And we don't really know how this conversation started up, whether Richard Ousley said, "Where are you going? What's happening?" or the jury said something to him. But the circumstances were very unusual, it has to be said. Anyway, Richard Ousley says, "What's happening?" And the jury said, "The judge has sent us home. There's been a shooting in the court." To which Richard Ousley replies, "Did they get the judge?" A pretty unwise thing for a man on trial for a serious criminal offence to say to a jury. Anyway, Richard Ousley heads back to his barrister's chambers at Owen Dixon Chambers. And his barrister was a man called Albert Blumstein, a very pleasant man and an intelligent man, a little bit disorganised. You know, he had his wig on, crooked and his hair down and his robes, and he couldn't find his papers, but a nice man and a competent man. So Richard Ousley walks into Albert Blumstein's room, and Albert says to him, "Richard, there's been a shooting in the court." And Albert says, "Yes, I know." "How do you know?" "The jury told me." At which point I believe all the blood drained out of Albert's face. And he said, "That's terrible." Albert said to Richard Ousley, "I'll have to tell the judge about this." So the next morning, we're all assembled in court. Mr. Winicky, Philip Cummins, Queen's Counsel and so on, the whole array of barristers along the table, and poor Albert gets up to tell Mr. Justice Beach what happened and what was said. And the judge took it remarkably well, and those of us who were at the bar table were nearly exploding with laughter, trying to look serious but exploding with laughter. The judge took it very well, and I can't remember what the consequences were, but it was passed over, and I think Mr. Richard Ousley may have paid a price for further down the track because he was convicted and sent off to jail in due course. So that was an extraordinary day and finished on an amusing note, even though it was a tragic event. Well, now, around about that time, there were several other incidents involving guns in court, together with the incident I've just described to you, led to a big clampdown on security in the courts, which was a pity in a way, but necessary. And I wasn't present at these other incidents, but there was one that Jim will know about. At around about that time, Mark Chopper Reed, who you probably heard of that, he tried to kidnap a county court judge called Bill Martin. And I think Chopper's plan was to kidnap the judge and then persuade the authorities to release one of his mates who was in jail and bring that fellow to the county court, and they were going to get a car and go to the airport and fly away. I mean, a harebrained scheme from a harebrained individual. So he produces out of his bag in court a sawn-off shotgun and rushes up, he's 18 stone, Chopper, rushes up onto the bench and points the sawn-off shotgun at Judge Bill Martin, who Jim will remember very well. And the judge, who was quite a formidable character, big tall fella, but not overweight, he very bravely pushes the gun barrel aside. And now, according to newspaper reports, which can be exaggerated, he kicked Chopper in a very sensitive area. And then the judge disappeared out the door at the back of the bench. Now, there's a door right at the back. In the old county court, sort of a secret door, you could hardly see it. So off goes Judge Bill Martin. In the meantime, the judge's associate, judge's tipstaff, I don't remember what a tipstaff is, he's sort of the court usher and a man called Ernie Trotter, who Jim will also remember. Also a very big man, but in a slightly different direction. But a very brave man with a big handlebar moustache rushes up onto the bench and tackles Chopper and gets the gun off him. And in the meantime, you know, the police arrive and Chopper's carted off. So that was one incident. The other incident involved occurring around about that time, the shooting in the magistrates' court of a man called Raymond Bennett, or Chuck Bennett. Now, Chuck Bennett was a criminal who was being escorted to a courtroom in the old Melbourne Magistrates Court. The whole place is like a rabbit warren, where Jim's dad worked as chief magistrate at one point. So Chuck Bennett is being escorted by two detectives up a stair, or I think they're about to go up a staircase, internal staircase to go upstairs. And a man suspected to be another criminal called Brian Kane steps up and shoots him dead with a handgun. And Brian Kane, if it was Brian Kane, he was the suspect, then escaped in circumstances that no one's ever been able to explain, because how you could shoot somebody and escape from that part of the Melbourne Magistrates Court is very hard to understand with all the police that were around. But it has long been suspected, including by some police, that he was assisted to get away by corrupt police. And I have had something to do with cases involving the police who were suspected of being involved. There were some rogue police around at that time, but no one's been charged, no one's been convicted, so I'll say no more about that, but except that it was a dreadful, dreadful incident. So 3 incidents involving firearms in court in a very short time, and now we have this extraordinary, but probably well, undoubtedly necessary security, which is a great pity, particularly in regard to the Supreme Court. The Supreme Court was built with about at least a dozen public entrances and exits to the building. It was intended to be a thoroughfare to exemplify the principle of open justice, that anybody could walk into the building, walk into a courtroom, listen to a court case. That's the way we like it to be, so nothing's done in secret. These days, like Fort Knox, getting in there, you take your shoes off, your belt off, and so on. And of course, it's a shame because people are discouraged from going in and listening to court cases, and they're rarely televised. So they all happen, in a sense, in secret. Okay. How am I going? I now move on to the most embarrassing thing that ever happened to me as a judge. And this was in the year 1990, a long time ago. I was a very junior judge and of the county court. And one Sunday afternoon, I had to go into the court to pick up some papers because I needed to work on them for the Monday morning. I hadn't taken them home on Friday. And the papers I wanted were in a courtroom, the courtroom I was working in. So in I go, there's nobody in the building, big building, nobody there. I've got keys and so on, I get in. And I had with me my 8-year-old son and his best friend, another 8-year-old boy. So they came with me. I just had to pop up to the courtroom, get the papers and head home. So the boys are obviously intrigued by the courtroom and asking me a lot of questions, including, Dad, where do the bad guys go? So we point out the dock at the back of the court. And the boys noticed that there was a cell just adjacent to the court. And the courtroom and the cell had just been renovated, all nicely done out. So the boys said, Dad, can we see what it's like in the cell? And I said, sure, boys. So in they go, and they said, Dad, could you please close the door? I said, sure. So the boys were in there for a while, and they said, Dad, we'd like to come out now. No problem. I couldn't get the door open. I couldn't get it open. So here I am, I'm a junior judge. I've got 2 8-year-olds in a cell, locked in a cell, in the county court on a Sunday afternoon. The first thing I have to do is to make sure the boys don't panic. So the cell door's about this thick. So I lie on the ground. Don't panic, boys! Settle down, Dad, we're fine. Don't you panic. So in those days, no mobile phones, 1990. I said, I'll have to ring Pentridge and get the guards to come down with the keys to the cell because the judges didn't have keys to the cell. So I had to leave the courtroom and go to my office, my chambers, some distance away, get the phone book out, ring up Pentridge. Ring Pentridge. Hello, it's Judge Michael Strong from the county court here. I've just accidentally locked 2 8-year-olds in a cell. Could you help me? There's silence on the line. Who is this really? So it got to a point where I had to say, now listen to me, Judge Michael Strong. Anyway, I got the message through, spoke to the assistant governor, and they were very good. And they dispatched, I think it was 2 cars, with 3 or 4 big burly prison officers and bunches of keys from Pentridge heading down Sydney Road to the county court in William Street. So I hurry back to reassure the boys, don't panic, boys, we're all right there. So we're waiting and waiting. I mean, it takes some time for these people to come down Sydney Road from Pentridge. So by this time, the boys are getting a bit impatient and start kicking on the door, pushing on the door, and the damn thing sprang open. It had been recently renovated and it was very stiff. Almost, this is impossible to believe, but I swear every word of it is true. Almost at that moment, through the other door leading down from the cells, in burst these three big prison officers. The boys and I are still standing there. I can't remember what I said. Probably very little. But they were very good about it. And I thought I would be in the Herald Sun the following morning, front page.
Truth.
Or Beak of the Week on 3AW. But they were very good. They obviously never mentioned it to anybody, and I certainly didn't mention it to anybody for quite a long time, except Jim and some friends, because I didn't want to be on the Herald Sun, front page of the Herald Sun for being such a bloody idiot. So that's what happened. My most embarrassing day as a judge. Have I got time for one other little story? I'll tell another little story. In 1993, I was finishing a very long case involving police corruption. It had gone on far too long, this case, and it was a very complicated case. And the prosecutor in the case was a man called Robert Redlich, who went on to become a very eminent Supreme Court and Court of Appeal judge. A very capable man, much smarter than me, but not a big sense of humour. Tended to take things a bit seriously, especially when I didn't agree with him, which I had to do as the judge every now and then. And of course, what I said went, because I was the judge and he wasn't, but he didn't like that often. So there was a bit of tension in the courtroom. Anyway, Robert did a very competent job, as he always would, and he was addressing the jury. His final address was a very long final address. I think it might have gone on for 7 or 8 or 9 days or something like that. Very long. So he was to finish the final address on a Monday morning. And on the previous Friday, just when we adjourned, he said to my staff, I'd left the bench, he said to my staff, could I stay back because I want to write on the whiteboard some final points that I want to make to the jury. Some final points, that 1, 2, 3, 4, 5, the 5 or whatever it was, 10 reasons why they should convict the accused man, who was a former policeman. No problem. So he was using one of those electronic whiteboards. Do you know the type? You write on them, then you press a button and it goes around the back, and you can write on another screen and press a button and it sort of rolls around. Do you know those sort of ones? Anyway, so he wrote up his 10 points on the whiteboard, why they should convict the accused. And then he pressed the button and back it went. On the Sunday afternoon, I had to go back into the courtroom again to get papers. I'm pretty disorganised, aren't I? So anyway, I had to go and get some papers from the courtroom. This time, I had with me my other son, who I didn't lock in a cell, I can assure you. I had my son, Ben. And while I was rustling around looking for my papers, Ben spotted the whiteboard. And which, it just was all white because Robert Redlich had rolled the other ones around. So Ben, who liked drawing, drew a great big picture of Homer Simpson on the whiteboard and then pressed the button and round the back it went. So the whiteboard was clear. And on the Monday morning, Robert Redlich, QC, very eminent barrister, not much of a sense of humour, was finishing his final address and he said, "Members of the jury, I think I can sum up the case against the accused man very succinctly by showing you this whiteboard." Presses the button, Homer Simpson. I sat there going, wonder what's going on here. Because I knew exactly what had happened. So that's as much as I'm going to say today, unless some of you have questions. And I've already alerted Jim, if the questions are too difficult, I'm going to flip them to him.
Okay, questions, gentlemen. Right down the back.
Graham from Keys, Michael.
Yes.
Particularly in the first part, bearing in mind you can't say very much, Do you ever have interface with federal authorities as opposed to state authorities?
No. We deal only with, we operate under state law and deal only with state law enforcement authorities. There's no Commonwealth, federal equivalent of the public interest monitor. There should be, because it's a system that works well. It ensures that applications are made are fair and proportionate and so on. And we work very effectively with the police, and they know that if they overreach, we'll jump on them, and they rarely do, and it works well.
Thank you.
Gotcha.
Very, very interesting stories are told today.
All true.
Just recently, many of us remember this because I used to work near the Silky restaurant, Chinese restaurant up in Warrigal Road.
Oh yes.
2 policemen were.
Yes.
What's the implications after 22 years of the convicted being now released? What's the implications for the police, and does the prisoner of 22 years have any recourse to somebody?
Look, has he been acquitted?
Yeah.
Oh, I didn't know. I'm sorry. I should have known that. He's been acquitted, has he?
Yeah.
Jason Roberts.
Jason Roberts, yeah.
What are the implications?
So it's off the cuff now, because you didn't know.
Well, he could make an application for compensation, and I'm sure he will. But it's a very long time, isn't it? Yeah. What happened in that case was, and this is all public knowledge, that some concerns were raised by, who was that former homicide squad detective?
Ron Eddles.
Ron Eddles had concerns about some of the statements made by the police about what Miller had said in his last moments about how many shooters there were, whether he'd said 2 or not. And IBAC, the Independent Broad-Based Anti-Corruption Commission, conducted an inquiry and found that there were irregularities in the taking of the statements, and that's why the retrial was ordered after all those years. But yes, Roberts could certainly, and I'm sure will, apply for compensation, but very hard to compensate.
What about the police? What can they do?
What can they? Well, the police involved have already. What can they do to, in what respect?
Well, because I think the people who were, the 2 policemen who were killed,
Yes,
their families would be so disappointed
totally.
that the person who was convicted and sent to jail for 22 years
Yes.
has now been released. So
Devastating.
they will be wanting to see whether the police are going to reopen the case to try and find.
No, well, the case can't be reopened now. The jury have acquitted him. We do have some rare exceptions to the double jeopardy rule in Victoria, but you know what the double jeopardy rule is. If you've been acquitted, you can't be tried again. A retrial can occur in very limited and extreme circumstances, but I'm sure there'll be no retrial in this case, particularly in view of the fact that the bloke has done 22 years. But yes, it's to say it's a most unfortunate case would be a great understatement.
Thank you very much.
Yes.
Tim Harding, yeah.
Tim Harding.
Would you agree that the very existence of your public interest body has a positive effect on the police in terms of the way they behave?
Oh, yes, absolutely. And it's sort of like we're in a sense a cop on the beat. They know we're there. They know that every application they make will be vetted by us. They know, as I said, that if they overreach, we'll object. And it's all settled down very nicely. The office has been in existence for about 7 years. They understand that they don't want to have arguments with us. They don't want contested applications in court. They happen very rarely, actually. We will say to them when the affidavits come in, we don't think there's enough evidence of this or that. We think you don't need a camera. We think a microphone will do. We don't think it's been established that the person's using this particular telephone and so on. And we'll usually agree. They'll say, yes, sure, we'll give you some more evidence, or we'll withdraw that part of the application. So it works well.
Alan Trumbull, my question to you is, given the expose culture of today, do you feel that morally we're shifting away from the standards that we used to believe in, and will a federal ICAC body do anything to help that?
Well, I don't think you could talk globally about standards. I mean, there are personal, moral values that people have. There are standards that parliamentarians might be expected to pursue, and so on, lawyers and so on. But I think a federal ICAC would be excellent. I think we need it. I mean, the fact of the matter is that in any state where an anti-corruption body has been established, they've had plenty of work. And the notion that a federal ICAC, if established, would have nothing to do because there's no corruption is just ridiculous. They'll have plenty of work to do, and the sooner it's established, the better.
Thank you.
I must say I'm not a fan of public hearings. I'm not a fan of public hearings, but I think they tend to be show trials of people who have never been charged or convicted. But I have concerns about that. But federal ICAC, great idea.
Yes, I can't see.
Duncan, is the secrecy that overlays your office itself a problem long term, given that most evil comes from activities that are not within the public gaze?
Yes, no, I follow that exactly, but secrecy is necessary because the police must be able to conduct certain activities covertly. It's just an essential part of the investigative process, and we're there to ensure that it's appropriate and that it's fair, as is the court and the tribunal before whom these applications go. So there are checks and balances, but the police couldn't do their work if there was too much exposure of exactly what sort of cases we deal with. And as I said, we're prohibited by statute from talking about police methodologies because they have techniques and devices and ways of getting information that they don't want the crooks to know about, and that's also necessary. So I think our office does provide that check and that balance, as of course all these applications have to go to a judge or a member of the Federal Administrative Appeals Tribunal. So 2 levels of checking to ensure that what's being done is appropriate.
There's another question down here. I can't see who it is.
Lord Gamble, could you tell me what the difference is in the functions of the High Court and the Supreme Court?
Okay, well the High Court of Australia is the ultimate court of appeal in this country. There used to be appeals to the Privy Council in London, but that was abolished quite appropriately quite some time ago now. But if you are convicted in a state court, your appeal would go first to the Court of Appeal or Supreme Court of the particular state, and if you're still unhappy, or in a criminal case or in a civil case, if the losing party is unhappy, they can go to the highest court in the land, the High Court of Australia, who won't necessarily hear your appeal. You have to convince them that you've got a point that's an important point that's worth arguing, or that there's been a great injustice. So they're pretty selective about which cases they hear, but it's the ultimate court of appeal in this country, based in Canberra. There are seven judges. It's modelled in a way, in some ways, on the Supreme Court of the United States, as is our Australian Constitution.
Yes.
Rod Morrell.
Thanks, Rod.
Michael, there seems to be a public perception that the police force is these days becoming overly politicised. Are you able to make a comment on that? I see no evidence of that, but I'm not really in a position to, any more than any member of the community, to make a judgment about that. But
I personally have no concerns about that at the moment. I mean, there have been appointments in the past that have raised eyebrows, but I don't think there's any reason for the public to be concerned about the politicisation of the police force at the moment. Police force operates independently of government, and believe you me, the police very firmly assert their independence if they need to. They're a very powerful body, the police, and if they feel that the government are leaning on them, they'll push back very hard. And I've certainly had seen examples of that happening. Well done. Thank you very much. That's been fun.
Thank you, Michael, very much indeed. It's the most interesting and educational chat. I do have 3 sons. And
Congratulations.
thank you. And I can relate somewhat to the story of your children being locked in a cell. I remember when my sons were young, I was thinking of all the options. To just have some peace and quiet every now and again. That would have been one, but I would have needed to work through you. But thank you, that was a wonderful experience. I'll call on our secretary and maintain the legal fraternity, Gary Sebo, to call for a vote of thanks.
Thank you, President. Our President read out a resume of our guest speaker at the start of his address, and I'm sure we'll all agree that he's had a very illustrious career, spanning many, many years. I looked up Wikipedia via Google to get some information about our guest speaker for today. Nothing there. Now, I cannot comprehend, and I won't push you too far, Michael, how it is you've been able to avoid having your details out there on Wikipedia. Perhaps it has something to do with your current employment. Look, I'm sure we'll all agree that Michael's talk was most entertaining, humorous, and enlightening. And it does just show that life in the law, despite what so many people say, is not all boring and dull, and there are some very interesting times. I must say, I didn't like your references to accountants either, because I'm also a qualified accountant. There's other accountants here. We have a different view of ourselves than you do, Michael. Nevertheless, it was a terrific talk. We're so pleased that you've come down and given us your time. And just as a small token of appreciation, I hope you like red wine. I do. And it's a pretty good bottle.
Oh, excellent.
So, thank you, Michael.
Thank you.
Thank you very much.